Let me tell you a fun fact. Within the last 2 centuries, more than 90% of the world's millionaires have been created by investing in real estate. But if done incorrectly, without the right knowledge, required skills, or partners, it can also create a ton of problems and a lot of sleepless nights. You feel like sometimes there are way too many gurus out there trying to sell you on a weekend course, or just too much noise to cut right to the facts? Yup, we did too, and this is why we started this podcast. Our goal is to provide real estate investors, entrepreneurs, and enthusiasts with all of the most recent knowledge, secrets, tips, tricks, and tactics so that you can grow your own portfolios, increase your returns, net worth, and most importantly, create generational wealth for you and your loved ones. Remember, this is your real estate career. Information is your sword and shield, so eat hearty, prepare for battle, and grind your way to victory. My name is Tejas Gosai. I'm joined by my partner, Jeremy Moyer, and we welcome you to the Real Estate Investor MBA podcast.
Hey everyone, welcome back to the Real Estate Investor MBA podcast. My name is Jeremy Moyer, one of your hosts, and I am flying solo today as my co-host Tejas Gosai is not able to be here. Please check out our new website, rei.mba. You can find all of our previous episodes there. And also, if you're interested in what we're doing, what we're working on, if you're interested in just following our journey with different projects, etc., feel free to sign up for the free newsletter that we have, just going and subscribing. We look forward to connecting with you along the way. But our interview today was with Kyle Swafford. So Kyle is an associate at Robinson Franzman, who is a commercial real estate finance law firm dedicated to assisting clients on capitalizing on opportunities and solving complex challenges. So Robinson Franzman is based in Atlanta, Georgia, and they serve clients all over the United States, government guaranteed commercial real estate lending, commercial real estate finance matters. They specialize in multifamily real estate, self-storage, office space acquisition, dispositions, and then also just general outside counsel matters for different financial institutions. We really dive into some unique and interesting topics today. A lot of common mistakes, sponsors can make in the one that just the private placement memorandum paperwork, any of those associated documents, other legal documents along the way. He touches base briefly on purchase and sales agreements, on management company contracts, etc. We kind of take a little unique dive and turn down different roads, really uncovering some interesting topics. So I really hope you guys enjoy the episode. Take care. Welcome back to the Real Estate Investor MBA. We're really excited for our interview that we have lined up today. Today we have Kyle Swafford. Kyle, how you doing?
Hey, thank you, Jeremy. I really appreciate it.
So Kyle, for folks who are not familiar with you, can you spend just a few minutes telling us who the real Kyle is, and how you got started in your line of work, and what do you do specifically?
Sure. So I guess a little bit about me. Our firm, Robinson Franzman, is located here in Atlanta, Georgia. Obviously, we do deals nationwide, but this is our home office, if you will. A little bit of background for me was I've always kind of been more of a transactional, corporate-minded individual. Even when I was in law school, litigation wasn't something that I was particularly interested in, whether that's, the ambulance chasers or slip and falls, whatever it is, probate, doesn't matter. I always kind of felt like a more transactional practice. What can you do to prevent litigation from ever happening is far more important to me than actually being good at the litigation. So I spent a lot of my time focusing on corporate classes, taxation classes. Once I finished law school, I went to the University of Florida and got a 1-year tax LLM degree, which is specializing in tax. That kind of put me in a corporate world working at Deloitte, doing international tax, one of the big four companies. From there, I did some, I wouldn't say litigation, but dispute resolutions representing people and entities against the IRS. And then ultimately kind of found my way into commercial real estate, and haven't looked back since. It's a great space, particularly the multifamily space, but really all of them as a whole. And we can get into that later. But I've really enjoyed it in this. Love the firm, love the work. So I think I'm here to stay, God willing. So we'll see.
Today's show is really more specifically talking about private placement memorandums and other associated syndication related legal documents. And then more specifically, like what are some common mistakes investors make, what they can do, or the law firms that help them out, what they can do to help protect them. So I guess, Kyle, to start everything off, can you just give like a high level overview of, what a PPM is, and then those other documents that are really crucial in the syndication world?
Sure, absolutely. So kind of a little fun fact, as far as the actual binding authority with the syndication documents, it's really just the operating agreement and the subscription agreement. With the subscription agreement, it's kind of in the name. You're agreeing to subscribe and purchase subscriptions of this entity and be a part of it. With the operating agreement, you're agreeing to how the company will be operated. Those are really the only two binding documents that you're going to have with any sort of PPM syndication package, if you will. The PPM is more of a one-stop shop that kind of has a little bit of everything. It probably has a little bit of your investment summary, kind of what the market looks like, what your renovation plan is, if you're doing a value add strategy, for example. It'll have a little bit about the operating agreement, how the cash flow is going to flow, in what ways and what percentages, what preferred returns, if any. And then it will detail a little bit about the subscription agreement, how many units are there, what it takes to be an accredited investor versus a sophisticated non-accredited investor. So it kind of has a little bit of everything. So that's where the PPM is really kind of the heart of it, because it's covering every aspect of it, of your deal, of the property, of the operating agreement and whatnot. So a lot of people think, well, I haven't gotten the PPM signed. Do I need to get the PPM signed? It's actually not a binding document, but it is nonetheless probably the most crucial document, because that's where, if the SEC, God forbid, is ever kind of looking into this deal, they're going to go straight to the PPM and just kind of see how everything was laid out, that's where your risks are disclosed, possible conflicts of interest, federal tax implications and whatnot. So it's by far the most important document, which is odd considering that it's not binding as a whole. Of course, this is with a syndication and not a joint venture. That can be something we kind of talk about a little bit later, but that's and painting with a broad brush. That would be how these documents kind of relate to each other. You have a PPM that goes down. It's probably your pitch deck of some kind. Then it's the operating agreement. Then it's the subscription agreement. So that's as exhibits to the PPM.
Okay, no, that's very helpful. So let's start to unpack the, I guess, common mistakes that you see. Do you see them in all the different documents? Do you see them within the operating agreements, or do you see them mainly within the PPM? Can you speak to that?
Yeah, so I think some of the times where I think you have what I call cosmetic mistakes, and then you have, kind of these more practical mistakes. I think cosmetically, one of the things that people often miss is that, what type of units are you giving? Some people will say Class A units for $50K investments through $250,000, and then a Class B unit, which is really the same thing, but you're just calling it something different because someone contributed more of an initial contribution. But then your pitch deck will refer to it as Class A1, Class A2, or other areas in the operating agreement will not align with what you're calling it. So I guess that's kind of a consistency issue that a lot of times that people will will miss is what are you referring it in your PPM, in your operating agreement, and then in your pitch deck. Another mistake that often happens is people will not adequately cover because remember, and this depends too, and I like to take this back a second. This depends more in a 506B context than a 506C context. With a 506B, and let me just briefly explain the differences with that. With a 506B, you're limited to 35 non-accredited but sophisticated investors of whom you have a pre-existing relationship with. So maybe this is friends and family, maybe this is people you went to college with or coworkers from previous jobs, whatever. You have a pre-existing relationship with these people. Because of the fact that there are going to be some people that subscribe to this investment that are not accredited, meaning as an individual, they have $200,000 for the previous 2 years with a reasonable expectation of doing the third year, or $300,000 under the same requirements if married, or a net worth of $1 million, excluding the personal residence, and all the other, types that can make you accredited, whether trust, entity, what have you. Because you're having people that are non-accredited, the argument is that this money that they're subscribing is a greater percentage of their net worth. So you have to adequately disclose everything, conflicts, statements within the operating agreement, because some of these people may not read the operating agreement. So that's why you have to put in the PPM certain information about the operating agreement. Certain information about the subscription agreement, risks. I mean, there are at least twice as many risks and conflict of interest disclosures in a 506B than a 506C. Part of that is because you're dealing with more sophisticated investors. There's less of a threshold. They're presumed to know a lot of these risks. So there's less that you have to explain in a 506C versus 506B. So having kind of briefly touched on that, one of the areas you see is that some people will not adequately cover what they mean with the cash flow distributions in the operating agreement that they do in the PPM. So because the PPM is the non-binding document, if your operating agreement, for example, is an 80-20 split, but the PPM saying a 70-30 split, you're going to be bound to the 80-20 split. Plus it looks messy. Your investors think that it's you're not even getting these documents right. How can we trust your business plan? That's what I've seen of deals that come into our firm, from a previous deal, and we kind of caught it after the fact. But that is a common mistake where an investor or a sponsor doesn't adequately cover what that cash flow is going to look like. One of the more practical, real things that I see and this happens more with newer sponsors, and I understand why new sponsors do this. The problem that I have is that a lot of sponsors are leaving money on the table by not doing a waterfall cash flow distribution, whether that be a IRR, which is internal rate of return, or the average annual return, AAR, whatever you're using. I think a mistake that a lot of sponsors are making is not putting in the waterfall distribution. So for the people that may not know what I'm talking about, cash usually back in the old days, if you will, it says a 31-year-old man. Back in the old days of stone tablets, people were using, an 80-20 split. And once they've got a couple of deals under their belt and the investors knew of their successful track record, they may have upped it to 75-25 or 70-30. A new innovative way of trying to make these deals a little more win-win, if you will, was if the sponsor gives the investors such a high return from their initial capital contribution, then the sponsor, having done such a successful job and making the sponsor more motivated and driven to effectively manage the property, should be compensated for that a little more fairly. So what some people have started doing is, we're going to offer 90-10 split off the rip. If we've made you an 8% IRR, then we'll do 80-20. If we've gotten you to a 16% IRR, we're going to do 70-30. If we're getting you to a 20 IRR, we're going to do 60-40. The reason now, keep in mind, you are most likely not going to hit that IRR hurdle without a refinance or sale, because the IRR is going to be based off of the return of the capital contribution. Stop me if I'm misstating anything here, Jeremy, but that's because I know this was kind of maybe not within what we were expecting to talk about.
This is good. No, this is good. You can keep going.
Yeah. So the way, whenever the refinance or the sale happens, part of the water flow at that point is returning portions. The way we drafted is either all or in part of the initial capital contributions. That's going to bump the IRR, particularly through the roof. So if once you've gotten that refinance, possibly in year 2 or year 3, depending on your renovation plan or your value add strategy, whatever that may be, what you could have done is, instead of doing this 80-20, situation, you could have increased it to where now, because of these thresholds, we're automatically getting 60-40. What does that mean? Well, now when you go to sell the property 2 years down the road, the sponsors now own 40% of the deal, which the investors aren't going to complain about, because they've gotten such a return off their capital, who were passive anyways. So I think and that's not really like a legal mistake, so to speak, but it's certainly a little negligent. You're kind of leaving a lot out there. And if you're a sponsor, you should be rewarded for all the hard work that went into this. A lot of people don't realize how much work goes into this if they haven't done it themselves. But the underwriting the deal, you probably underwrote 50 deals before you finally submitted a LOI on 10 of them, before you were finally in second place on one of your LOIs, before you finally, added a little more temerity and put forth a little bit more purchase price to finally get one under contract. God forbid the first one you finally get under contract, was you get through the due diligence and you don't want to go through the deal. So you start all over again. Now I'm not saying just haphazardly run off a cliff or anything like that, but you finally get a deal, you finally close on the deal, you get your acquisition fee, you're implementing your value added strategy, you're hiring a property manager, dealing with the brokers, all of this work, managing the property, staying on top of your property management company, making sure that all the securities were filed, the money's there. When are we going to start renovating units? How are we going to get people out of their units? Are we going to offer 6 months of the same rent at a more renovated unit? That impacts our cash flow. All the things that go into being a sponsor. You've done so much over the course of 3 to 5 years. To not have an IRR waterfall of some kind just really seems like you're leaving so much on the table for all of the work that and it's not like it's just free. It was earned, it was deserved. I will say too, another mistake I think that sponsors run into is really a mistake that a lot of us make. Sometimes we might be reluctant to cut off relationships that we already know, kind of the devil kind of theory. But there are a lot of times where a property manager might know that you're kind of newer to this situation, and they might be padding invoices. Let's say, for example, that you have this contractor, and or hopefully that the going rate on the countertops, flooring installations, and appliances for an apartment complex of this size in Tampa, Florida, is probably about $5,000 per apartment complex. And then you're getting a bill for $7,500 per apartment complex. Maybe because of supply chain issues, that's not that uncommon, but you kind of have to ask yourself, why is this high? So we've seen situations with our clients where their property manager was going to the contractor saying, if you bump up your fee, I'll get it approved through the owner, and then we'll split that bumped up, 1/3, 2/3, whatever. Mm-hmm. That happens all the time. That happens all the time. Or something else, maybe the property management contract that you reviewed has a clause in there where their fee is based on occupancy, not so much rent collected or, income driven, if you will. If that's the case, they have no incentive to really push raising the rents. Now you can push them, but if they're not going to actually implement it, then you're going to have to get rid of them or you're subject to them anyways. Right. So that can be a situation where, well, them, they kind of are there and a lot of people are familiar with them. If you're running into situations where you're worried that, maybe they're kind of cutting some deals behind your back, or they're lying about the income so that they can get their cousin into the apartment complex who otherwise wouldn't have met your ×3 income to rent requirement. You need to cut the ties quicker there than not. So that's kind of a mistake we see at times as well.
Can I stop right there?
Yeah.
We just covered a lot. What you just said makes a tremendous amount of sense, and I think that also speaks to, when you're acquiring these larger assets, you're doing syndications or even joint ventures, right?
Mm-hmm.
Where you have multiple parties involved. Like, it's extremely important that you're not the only one, like, doing certain operations, as you just said, and it's so true. There's a tremendous amount of work that goes into this. A lot of different skill sets. So it is really crucial if you can have someone that's local to that market that's on your team, or especially if they have a background in the trades or in construction, they can review those numbers and like almost a litmus test, like this makes sense, this doesn't make sense. So that you speak to that in what you just reviewed. Going back to, I want to come back to the property management agreement in a second, but going back to the risks that are outlined in the PPM, especially in like the 506Bs, as you mentioned, you have to be a little more, not a little, probably a lot more detailed. Do sponsors typically, or do you advise them, you mentioned it was non-binding, but do you advise them to have the not the private investors, the limited partners that are investing the capital, sign off on those risks and initial those risks that, like you mentioned, they might not be reviewing the operating agreement? There's a lot of paperwork to review. What do you make sure the sponsors make sure that are being reviewed specifically, and that they're signing off on that?
So that's a really good question. And I think you could ask different securities attorneys this question. You could ask 5 different ones this question. You're probably going to get 5 different answers. The way that I approach that is sometimes just from a practical standpoint, some of your investors might be coming in through self-directed IRAs, and the IRA institutions don't even need the PPM, don't even care about the PPM, typically just want the signed operating agreement, subscription agreement in order to release the funds. So to the extent that you do have people, coming in through a self-directed IRA, you would otherwise be making them sign documents that they're not even going to need. The way that I've handled that, and the way that our firm handles that, is we have in our subscription agreement, for example, that by signing this subscription agreement, you're agreeing that you've read the entirety of the private placement memorandum dated April 12th, whatever that date is. The reason is you don't want to get into a situation where you don't have some level of protection. If you didn't read that, that's kind of on you. But the way that I know that you said that you read it is by signing the subscription agreement. Some people will have people initial their risks and disclosures. My argument would be, if you're going to make people sign their risks and disclosures, you might as well have them initial every page of this 45, 50 page PPM, because there's so many conflict of interest that are just as important. Is the property manager an affiliate of the sponsor? That's far more important, arguably, to some investors than whether there's enough risk being disclosed, right? Is there going to be a joint venture? Will the property manager be an affiliate of that joint venture company, the preferred equity group? So I wouldn't say that I would make them initial every line, because our documents are prepared in a way that that's covered through the subscription agreement. That is a good question, though. Overall, some people probably do that. We don't think it's necessary. That's not going to be why you lose as a sponsor some sort of case or investigation with the SEC. Typically, it's because you really didn't have a pre-existing relationship with this investor that blows the whistle on a deal that went south, or you were soliciting or advertising this deal in violation with the regulations that otherwise say you shouldn't have. Again, this is a discussion of 506B. That's where people are going to get caught up more with the SEC. It's not going to be because somebody didn't initial a risk disclosure page.
Okay, no, that makes sense. Thanks for explaining that. So I wanted to go back to the property management, the example that you gave. With the occupancy example. How important, let's say like a team, a sponsor team does not have someone that's very strong, part of that team in legal document review. So, how important would you say that you have, your attorney group, maybe, the securities attorney or another attorney group review those type of agreements just to make sure everything's on the up and up, or nothing was missed inadvertently or, on purpose, from the management company trying to slip stuff in.
Right. No, I think it's very important. A lot of times, and of course, this will depend on the size of the deal, the sophistication of the lender, the sophistication of lender's counsel, the checklist and whatnot. If you're getting a larger acquisition, say $25 million, they're going to want to see the property management agreement. The lender, when I say the lender is going to demand to see the property management agreement. They want to make sure that the lender is always going to want to make sure they come first.
Sure.
They're often going to make you sign a subordination of management agreement, which would be for the property manager anyways. But a lot of times that comes through the process of the natural closing timeline, because the lender's going to want to review it. So your attorney should be reviewing that anyways. To the extent it's a smaller deal or it's already closed and you're looking at a new property manager because you want to replace your current one, maybe you brought on the same property management company that the seller had, and it's just not working out in the way that you want it to. I think it's always important to make sure that your attorney does review the property management agreement, even if it's a post-closing matter, even if it takes 2 hours, worst case, which is, maybe an hour reviewing and an hour discussing. You now know that it's been reviewed by your attorney, either okayed or redlined. And you want to make sure that this is actually a really good example. What if they retain the entire right to hire and fire, but you've gotten information from reliable sources that your handyman is, God forbid, being inappropriate to tenants, whatever that means, and tenants are feeling uncomfortable with him being around, coming into their home, men, women, doesn't really matter. You probably would want to say, hey, this isn't working. You need to go. And it's like, no, he gets everything done on time. It's like, yeah, but it's not working. Someone else can do it. You may not have the right in your contract to fire the staff. Now, obviously your leverage is, look, either you let him go or I'm going to let you go. You kind of like an NFL owner there, either the coach goes or you go, I don't care. But you want to make sure that your attorney kind of covers everything for you, because I would have saw that and immediately redlined it. I would have saw an occupancy requirement and at least highlighted it and asked, if my client was aware that's how it was going to operate. Just little things that come up within that property management agreement that you just want to make sure that your client is taken care of. Because like I said a second ago, I understand that, people need to be protective with their money. And when you're operating a business, you're not in the business of giving it away. I understand that. But in the grand scheme of things here, we're talking about maybe $500 to $1,000 to review an agreement that is going to be a large impact on the net operating income of several tens of hundreds of thousands of dollars on a multiple $1,000,000 property. Just get it reviewed. Just get it reviewed. It's a write-off anyways. There's no, I don't think that's where you cut corners. Legal binding documents. Particularly when a lot of these property management companies have their own form documents that they just send out that is so heavily in favor of them. For the same reason you wouldn't have signed a broker PSA, hopefully, is the same reason you shouldn't sign a form template property management agreement. I'll say that.
No, that's great. I love that. I wasn't even thinking we were going to get into this type of detail on some of these other documents, but I'm glad, the conversation went that way, because it's,
sure.
I think you hit the nail on the head. Just investors need to be mindful and prudent, and, just be aware, that not everything, as you just mentioned, you could take at face value. These agreements, you can negotiate them, right? Because you were given them those. So that's great. So, we are want to wind down the show in a little bit, but can you give one other example of risks that are just on the table that we haven't reviewed yet, specifically with, either the syndication paperwork, that entire process, or, more along the lines of legal agreements, with, going through the business plan, right, of executing on what you need to do with the asset that you just bought.
I think, man, I could spend just as much time that we've been already doing that. I guess this is probably what I would say. I think sometimes as a sponsor, sponsors, like anyone listening to the show, perhaps you yourself, need to have a thorough understanding of everything that's going on at a base level when it comes to some of these legal matters. Some attorneys like to have this philosophy where they keep their clients in the dark because it means the client will always come back to them. That's not how I operate. I want my client to be able to understand exactly what I'm doing, so that by the time we're on our third, fourth deal, we're just, moving very systematically. Because investors are ultimately going to ask you questions like this, and well, let me get you onto my attorney. I don't want that. Your attorney should be a part of your team in the same way you have a broker relationship, in the same way you have a property manager relationship, in the same way you have lender relationships. Your attorney should be part of your team. An attorney shouldn't look at you like you're someone from which I get a fee, and you shouldn't look at your attorney, in my opinion, as someone that is a means to the end. I think it should be a mutually beneficial relationship, and it often is, as it should be. So I say that a lot of times your attorney is going to have, your attorney should be good enough to see these issues coming up ahead of time. For example, if you're a new sponsor and it might be difficult for you to get financing, your attorney should be advocating for, to the best extent that he can, making sure that there's a financing contingency within the purchase and sale agreement. Whereas even if it's non-refundable, even if the money went hard because of the expiration of due diligence, there's an argument to be made. It should come back because the contingency of financing takes precedent on the entirety of the contract. So whether some money went non-refundable or not doesn't matter. The contract itself is void because the contingency wasn't met. Your attorney should fight for things like that. That's actually come up several times with cases that we've had. So I would that would probably be one. Just making sure that your attorney kind of knows what they're doing. Is your attorney, does it know what a rent-ready credit is? Because a lot of these times these sellers will get this PSA signed in January, for example, already looking about that trip to the Bahamas that they're going to get once it closes, and they're not even keeping tabs on the units anymore. And they might have had tenants that trash the place, and then you go in there at the closing and 6 units out of 60 aren't even rentable right now. Well, that's a tenth of your business plan that you might have to spend a month or so getting ready to get back up. That impacts the investment. So there's a lot of things that if an attorney, there are a lot of commercial real estate attorneys that do syndications, but that doesn't mean there's a lot of commercial real estate attorneys that do multifamily, that do self-storage, that do office space. And that's one of the benefits that Robinson Franzman has. If you're getting into a multifamily purchase and sell agreement, that is entirely different than a self-storage, purchase and sell agreement. And we know that, and we construct them in ways that are beneficial to our client as they can be, which is, really our role in our job. So I think that's so forgive me for my shameless plug there. But that's one of the benefits that you need to look for in your attorney is, do they know everything from start to finish? They're not just a real estate attorney. They're not just a security attorney. They're everything rolled into one, and it's more efficient that way. So that would kind of be what I would advise. Just make sure you have an attorney that knows what they're doing, that when you explain to them what you need, they can adequately shoot for that for you in the PSA or whatever that document is.
No, I love what you just said there, Kyle. Like it's important that they have knowledge in these niche spaces,
Mm-hmm.
but if you can find, and they are such a crucial component of your team, right?
Mm-hmm.
If you look at them more as a team member, they have not only that niche experience, but also they have a large enough holistic experience where, they're not only in this one lane, they're a team member, they're a legal team member. They can wear these different hats for you, not just in one part of your cycle. They can help you out through the entire cycle. So,
right. And usually, clients, a lot of times attorneys like us or, other, law firms of similar size and rapport have clients that have been doing this for a long time. So if you're coming in as a newbie client, for example, a new sponsor that hasn't done his first deal yet, your attorney very likely has a client that has over 3,000 units under their management, 4,000, 5,000. That particular client is doing their first deal this month, not even a period. A lot of times your attorney will be able to say, look, this is what he red flags over here when he's doing his due diligence. This is how he structures his deals. I like what you're doing over here, but let's pick you up to speed quicker and faster, because the whole goal is to make you successful and succeed. Right. So, if you're dealing with an attorney that has a large client base, he's probably seen things before, like, hey, every time our client sees a building built in 1965 with copper plumbing, it's a red flag for him. Mm-hmm. Random example there. But it happens a lot. So, hopefully you have an attorney, if you're a new sponsor, that has seen this before and can kind of get you along the ways as well.
No, tremendous. That's awesome. Thanks, Kyle. So in closing, like, how can our listeners, get in touch with you if they want to learn more about the firm, if they're interested in working with you? What's the best way for them to do that?
No, absolutely. So you can reach me on LinkedIn. My name is Kyle Swafford, and I believe you're going to share some information as well, but I'll just go ahead and spell my name if that's okay with you. Kyle, Kyle, Swafford, S as in Sam, W-A-F as in Frank, F as in Frank, O-R, D as in David, Kyle Swafford. On LinkedIn, my email address is Kyle, K-Y-L-E, at RF, for Robinson Franzman, LLP law.com, Kyle at RFLLP law.com. And then my office number is 404-255-2503, 404-255-2503. And to the extent that anybody does reach out to me from this podcast interview, please let me know that you found me through this podcast interview. That way I have some sort of context and understanding of where you're coming from and why you might have reached out. That would be really appreciative. And Jeremy, just again, thank you so much for having me. I really appreciate it. Thank you for having me on. And I really had a good time today. It was good.
No, likewise. Absolutely. So we'll share all that information that you mentioned in the show notes. If you're listening to this on any podcast platform, or if you're watching this on YouTube, you can find all this information in the description. But Kyle, once again, thanks so much for your time. This is Real Estate Investor MBA. I'm Jeremy Moyer. We'll see you guys next time.
See ya. Thank you.